This meeting of the Tom Lantos Human Rights Commission will come to order. Let me begin by thanking all of you, especially the left behind parents, for joining us this afternoon. There were many more that would have loved to join us in person, especially since the International Parents Conference is taking place today here in Washington. But of course, COVID has changed all of our plans in so many different ways, but they are absolutely here in spirit, and many are watching this hearing as we meet. Today's hearing will examine the implementation of the Sean and David Goldman International Child Abduction Prevention and Return Act of 2014. Our very first hearing on international parental child abduction was held by this commission back in December of 2009. Internationally recognized legal expert Patricia Appy, who will address us today, was not only David Goldman's amazing attorney, she also testified at that hearing. And when we wrote the law, she actually helped us write it. Between 2008 and 2020, more than 12,350 American children were reported abducted internationally by a parent. If there is good news to be had, it's that since the signing of the Goldman Act on August 8th, 2014, there has been a decline in the number of American children abducted overseas from an average of 1,250 a year between 2010 and 2014 to 690 a year from 2015 to 2020. However, the rate of return of children to American parents has worsened from an average of about 50% to about 40%. One reason I think that we have seen a decline in abductions is because the Goldman Act and its Department of State annual report on international child abduction and the prioritization that this commission, this Congress, all of us have tried to get state to take to make this a priority. That's something on page 15 of Talking Points. All of that has helped to contribute to some of these successes. However, the worsening rate of abducted children returns is curious. It raises questions about whether the State Department is using the full range of diplomatic tools provided by the Goldman Act. I think not. In order to address concerns like this, we have invited the Department of State Office on Children's Issues to be here, which is considered, as you all know, the U.S. Central Authority pursuant to the Hague Abduction Convention, to provide background and explanation and goals with respect to the 2021 report on international child abduction, including country compliance trends, and to discuss the implementation of the Goldman Act. However, State declined our invitation to testify at this hearing, which is deeply disappointing. The invitation to testify, however, remains active. We want to hear from the Biden administration on these critical matters. Delay is denial, especially for the agony that is suffered by left-behind parents and their children as well. Left-behind parents and their children that they love and cherish absolutely deserve answers, and they need them now. As many of you know, the Goldman Act requires that the Secretary of State issue diplomatic or sanction actions to address international child parental abductions with countries that have a, quote, pattern of noncompliance, and that bilateral agreements are pursued with countries that are unlikely to become convention countries or that have unresolved abduction cases that occurred pre-convention, just like Japan. To date, MOUs have only been negotiated with 5 non-convention countries over a 16-year period, and none since 2019. One question we have for the State Department is why aren't there more MOUs, including Japan, including for convention countries to help resolve those pre-convention cases. Furthermore, since 2021, the annual Department of State Foreign Operations and Related Programs appropriations legislation has included, and Andy Harris is here, a distinguished member of the Appropriations Committee. There's a provision authorizing the Secretary of State to withhold certain bilateral economic assistance funds for the central governments of convention countries that the Secretary determines are, quote, not taking appropriate steps. To date, the Secretary of State does not appear to have withheld any funds pursuant to this provision, despite Congress, in a bipartisan way, providing them with this tool. What are the costs of this failure to advocate on behalf of abducted children and left-behind parents? As the State Department itself has noted in its 2010 report on compliance with the Hague Convention, and I quote in pertinent part, abducted children are at risk of serious emotional and psychological problems, Research shows that recovered children often experience a range of problems, including anxiety, eating problems, nightmares, mood swings, sleep disturbances, aggressive behavior, resentment, guilt, and fearfulness. As adults, individuals who were abducted as children may struggle with identity issues, personal relationships, and possibly experience problems in parenting their own children, close quote. And as one who has not experienced this directly can only imagine, this can be extremely painful and traumatic experience for children, but also for the parents who are dealing with heartbreak, agony, and pain from being separated from their children. This separation can have long-term psychological consequences then for both. We must remember that we are dealing with the wrongful separation of children from their parents, a violation of the rights of both the left-behind parent and the child or children. Many of these parents have not seen their children in years and struggle to overcome the financial, legal, cultural, and linguistic barriers to bringing their children home from a foreign country. We as Congress and as the U.S. government must do what we can to reunify parents with their children. Child abduction is child abuse. These young victims, like their left-behind parents, are U.S. citizens who need the help of their government when normal legal processes are unavailable or have failed. While following the convention process has helped some left-behind parents be reunited with their children, there are many who are still left behind, including pre-convention cases dating back to before a country has ratified the convention. Nor is convention ratification a magic bullet. Some convention countries have a pattern of noncompliance, including Brazil, Costa Rica, Romania, and Trinidad and Tobago. These are all countries which have ratified the convention but failed to live up to their commitments. We all remember Brazil with David Goldman, the very people who would be go-to people for Hague cases actually represented the taking parent. And it was just, they knew the ins and outs and frustrated, but thankfully Patricia Abbey was there to provide that expert legal assistance and guidance to get them through that. Each country and each case, as we all know, is unique, as are the cultural values that are reflected in the laws of each country. Why, for example, do we face such challenges in Japan, a country with which we otherwise enjoy not just good, but excellent relationships? Japan apparently does not recognize the concept of joint custody, which is unusual among developed countries. Indeed, or instead, the courts give custody to one parent, applying what is known as the continuity principle. In other words, if the child is settled in one household, one shouldn't disturb him or her. Time for that to change, absolutely change. Not only does the law not punish a parent who absconds with a child, it rewards the abductor parent. This arguably is rooted in Japanese culture. Traditionally, it has been explained in an article in the Washington Post. Children are not viewed as individuals with rights or as belonging to their parents, but as property of a household where they live. As soon as children move to a new household, the estranged parent becomes an outsider. That is why bilateral agreements can be effective. They can be crafted to the specific country to address their unique obstacles in returning American children to their parents. It also can be used to address pre-convention cases. Part of the intent of the Goldman Act was not simply to reform the system, but to bring about a fundamental change in U.S. diplomacy so that the Department of State officials could see themselves as advocates for the return of abducted children, American children. The Act also provides the Department of State with tools to use in their advocacy. The Goldman Act specifically lists increasingly escalating actions, from a simple démarche, which is like a slap on the wrist, to a public condemnation, to a delay or cancellation of one or more bilateral visits, and even the withdrawal, limitation, or suspension of foreign assistance to the central government of that country. Extradition is another tool, yet these tools beyond démarches are seldom ever used by the Department of State, and I urge the Department to use all of the tools embedded in Goldman. Meanwhile, in Congress, we should consider tools that are tailored to meet the situation in certain countries. And in case of Japan, I can disclose to you that we are in the process of drafting legislation that will provide the State Department with additional tools that should be helpful and specific with respect to Japan. This hearing and your testimony today will help inform that legislation. It will help inform, hopefully, that we pivot and begin in earnest an effort to make this law, but above all, the reunification of those children with their parents, a reality. All these tools are aimed at uniting American children. We saw success, and Bill Posey, who will be joining us shortly, threatened sanctions against Lebanon in June of 2019, resulting in the resolution of 2 outstanding abduction cases that he was working. When there is pressure, there are results. The Goldman Act has empowered the executive branch with serious tools, with sanctions, to promote adherence to law and to return American children. Use them. I'd like to now yield to my good friend and colleague, Commissioner Andy Harris.
Thank you very much, Mr. Co-Chair, and thank you for calling another hearing on this vitally important topic. Unfortunately, since our last hearing on this topic, not much progress has been made, as you have noted in your opening statement. I'm particularly alarmed at the Department of State not sending someone to the Human Rights Commission hearing. The Department of State is one of the main departments and agencies in our government that is tasked with protecting human rights worldwide, using diplomacy to advance human rights worldwide, and yet don't find it important enough to come to this commission. I hope I don't have to address this in an appropriation at some point in the future, but the failure of the Department of State to use the full range of diplomatic tools to solve this problem is troubling. As the co-chair knows, my office, as many congressional offices do, have been follow some of these cases for years. In my office's case, it's a case involving Trinidad, which, as the co-chair has suggested, has a pattern of noncompliance. Although my case was a pre-signatory case, that doesn't mean that the government shouldn't be doing everything they can to address this human rights issue. And the MOUs, again, it would be wonderful to know from the State Department why more progress hasn't been made, but I guess we're not going to hear about a lot of that today because they simply chose not to be here. Mr. Chairman, Mr. Co-Chair, this is, again, an ongoing issue that Congress does need to deal with. If the State Department is unwilling to advance as quickly as possible in complying with the tools that Goldman gives us, or in advancing these memorandum of understanding, or dealing with agreements, bilateral agreements for pre-signatory cases, then we should take action through the means that are available to us, which would include legislative means or through appropriations. And again, I would hope that the State Department has a good reason for not being here today. They were at our last hearing on this topic, and again, I hope that they bring a lot of these countries that are non-compliers into compliance on this vital human rights issue. So again, Mr. Co-Chair, thank you very much for convening a hearing on this important topic.
Dr. Harris, thank you so very much for your advocacy on behalf of your constituent, but above all for your strong support for this entire effort over the course of many years. Jim McGovern, our co-chair, is actually on the floor managing a bill, so he will join us as soon as possible because he is also committed deeply to this resolution of these issues. Thank you, Dr. Harris. I understand there's Sheila Jackson-Lee will be joining us, but she's not yet to her PC to get online, but she will be joining us shortly. I'd like to now introduce our distinguished witnesses. Beginning with Patricia Appy, who is an international interstate family law partner with Pararis, Appy & Reese, a New York-based law firm that specializes in family law. She has directed the international litigation of child custody disputes throughout the world, serving clients in a wide range of cases in signatory countries and non-signatories to the Hague Convention on the civil aspects of international child abduction. Her expertise ranges from crafting enforceable multi-jurisdictional agreements to managing complex international parental abduction matters implicating international treaty law and global law enforcement. Among the many countries in which she has litigated, have been qualified as an expert witness or served as a consultant on international family disputes are locations as diverse as the UK, Brazil, United Arab Emirates, Italy, Pakistan, Australia, India, Japan, South Africa, Israel, Lebanon, and Canada. Of note, she successfully represented the Left Behind father, David Goldman, in the repatriation, I should say, of his minor son from Brazil, Sean, a case that gathered worldwide attention to the application or lack thereof of the Hague Convention. She has testified 6 times before Congress before the Subcommittee on Foreign Affairs, and she has, as I said in my opening, been really critical in helping us draft legislation, the Goldman Act, and the work that she did for the DOD in advising the Department of Defense on issues related to child abduction is, I think, legendary. In addition to being an award-winning filmmaker, Jeffrey Morehouse volunteers much of his time as executive director of Bring Abducted Children Home. Bring Abducted Children Home is a nonprofit organization dedicated to the immediate return of internationally abducted children wrongfully detained in Japan. It also strives to end Japan's violation of the right of children to have access to their parents. Back Home, as it's the acronym, works to increase public awareness through outreach on the crisis. He collaborates with an alliance of international partners working to end child abduction to and within Japan. He is founding partner in the Coalition to End International Parental Child Abduction, uniting organizations to work passionately and effectively to end international parental kidnapping. Between 2015 and 2019, he testified and briefed the U.S. Congress 6 times. Through his U.S. sole custody order, he was recognized by the legal courts in Japan in 2014 and 2017, yet his son, Mochi, remains kidnapped and cut off from him, even though he has won in court on several occasions. That has to change. Dr. Noel Hunter is the president and co-founder of I Stand Parent Network, Incorporated, a non-governmental organization that empowers parents to recover children from international child abduction. Dr. Hunter co-founded I Stand Parent Network after successfully recovering her daughter from an abduction to Mali in 2014. Since 2014, I Stand has assisted parents with reunifications of 54 children who were parentally abducted or wrongfully detained. I Stand works cooperatively with local, state, and federal agencies, members of Congress, NGOs, and has truly made a difference. Dr. Hunter has served as an invited witness to before the U.S. Senate on Foreign Relations, Committee on Judiciary, House of Representatives, and including my subcommittee in the past. She has also offered expert testimony before the Commission on Security and Cooperation in Europe and served as a consultant to the U.S.-based National Criminal Justice Training Center. Dr. Hunter received the Humanitarian Award from the Alabama chapter of the NAACP. She is former Dean of Students at Ohio Valley University and taught government and international relations at West Virginia University and Morehead State University. She is former Walter Rollins Scholar for the West Legislature and a James E. Webb Fellow at the Smithsonian Institution Office of Policy and Analysis. She is currently a lecturer of political science at the University of Alabama in Huntsville, and she has 3 daughters. I would like to now turn it all to Mr. Shabby.
Thank you, and thank you again for inviting me to offer my observations. I would quickly and enthusiastically correct the record that you've just indicated. My law office is in New Jersey and not in New York, and Monmouth County, New Jersey in particular. So just to be sure that we're reflecting that I'm a New Jersey lawyer. The first thing that I would respectfully request is I don't intend to read my remarks and would ask that my remarks be accepted by the committee.
Without objection, so ordered.
Thank you. That'll allow me to just highlight some areas of particular concern that I would like to share. First, I would challenge the number that you shared in terms of children who have been abducted at 12,350. I believe that is an underreporting. I believe that because of the difficulties that we have begun to see in many countries, parents have made the choice not to report abductions because they do not feel that there is direct relationship between the reporting and any services that might be provided in doing so. And in some cases, they may even feel that it offers a disadvantage to them. The other thing that I would say and heartily agree with is that the preventative aspect of this act has grown exponentially since 2014 when it was enacted. As my remarks in more detail indicate, at least 26 states require a judge to refer to the report as they are assessing the risk of removal or retention. If they are looking at, for example, a request for a parent to be able to go to another country for travel or to be permitted to relocate with the promise that there will be a shared international access, in those states, they must look at the designation that the Department of State has indicated with respect to whether or not there is a conforming or non-conforming state. They also have to look at the reasons why that designation has been attached. And that is the gravamen of my concern with respect to the prevention aspect. The report has become, unfortunately, less specific. It has, as I've referenced in my remarks, it uses what I would call sort of blanket language, boilerplate, that is repeated over and over and over again in each individualized country report. Now, why is that important? I have actually been in a hearing in which a judge was referring to the report in a case in which there were deep concerns about a child traveling. And the judge looked at me and said, I've read the 3 country reports in advance of this and the 3 country reports that follow it, and they say exactly the same thing. How does this help me to draw an assessment with regard to the actual status of obstacles to recovery of a child? And that's the most important piece, and that is the evaluation of obstacles to recovery. In this situation, if we look at the non-compliant states, and it's extremely important for a whole host of reasons, that when there is a designation of non-compliance, that there are a host of things that must take place in order for this report to have any seriousness at all.
Sappy, I hate to say this, but there's 5 minutes left on the vote. We have 3 votes. I plan on waiting a minute or 2, voting for the second one, and then coming back and reconvening the hearing. I apologize
No
to
worries.
all of you
I'm at your
for that.
convenience.
Okay, thank you. We temporary recess for the commission. The commission will resume its hearing, and again, I apologize to our witnesses and to all of our guests for that delay. There were 3 votes, so we'll move on. And Patricia Happy, the floor is yours. And again, for all of you, go as long as you would like. I think it's important to get all of this important information, not only on the record, but for everyone to hear orally as well as through the written form.
Thank you, Congressman Smith. I had left my remarks before our adjournment to discussing the importance of the way that identified non-compliant states are treated. These are states that have already been objectively identified as acting in recalcitrance, either with respect to their treaty obligations or with respect to their willingness to cooperate. With respect to the treaty obligations, I actually provided in my written remarks an example in talking about Argentina, and I won't go through all of the fact pattern other than to say this. Argentina has been identified, as has Brazil, as non-compliant states long before even the Goldman Act became law. And yet, we do not see actions being taken to move any type of diplomatic sanctions beyond a démarche. We do not see, for example, an engagement with respect to entertaining MOUs that set accountability standards for what is the next step. And frankly, if there is going to be persistent noncompliance, making a determination that a state of non-reciprocity exists, and therefore American judges are no longer obligated to return children pursuant to the treaty. Now that's an extraordinary remedy, but the fact is, if there is no treaty reciprocity, which is what the entire Hague Abduction Convention is based on, then it's an illusion if we are taking the position that we are both acting not only in good faith, but in the best interest and ensuring that children are returned to the place in which the evidence and their habitual residence has been identified. Argentine lawyers have asked for us to act in this situation. In my report, I've added the remarks from lawyers, experts in the countries involved, indicating that they see that this is broken, and they do not understand why there are not steps being taken to address it affirmatively, rather than simply saying we're going to continue to take steps to address noncompliance, which is the repeated phrase. With respect to India, a non-signator, I feel like I'm having a conversation of Groundhog Day. We continue to address rising numbers. The response that has been given from NGOs in India, and from what I understand has been given as the reason for reluctance, is referenced to the issue of domestic violence. Let me say that my assessment of that response makes no sense, because if someone is alleged to have left the United States because they are the victim of domestic violence, the United States has far more domestic violence protections than are available in India. So the issue must be more than the issue of domestic violence. There may be concerns about, for example, immigration issues. There may be concerns about access to resource. But India has, in the last year, was requested to be part of a joint commission by the United States Department of State, I would hope, as the precursor to a negotiation of an MOU. That's my hope. It's not listed anywhere, but that would be the logical first step. They refused, over a 12-month period, to participate. So my question is this: the numbers are rising. They've indicated that they are not cooperating. They've been invited by the Department of State to engage in a joint commission and to presumably explore the reasons why they do not feel that they can sign on to the Hague Abduction Convention, and presumably to explore an MOU as to what steps can be taken to support these issues or ameliorate the concerns that they have, and they will not cooperate. Why were they just issued a démarche when they refused to participate even in a joint commission? And why, given the arrangement and given the relationship that we have with India, the largest democracy in the world, why are we not using our diplomatic efforts in order to indicate to them that if you will not participate in this, and if you continue to be recalcitrant, we are going to have to use other means in order to impress with you with how important this issue actually is. My belief is that in most of these cases of the countries that are listed as non-compliant, they simply don't believe it's an area of import. The use of an MOU is also and should also be used in cases and in countries where we have started to or have historically used an MOU. I don't understand why we haven't revisited the MOUs that were originally drafted for Jordan and for Lebanon and for Egypt. Why we're not sitting down and talking about updating them, about addressing the current status of their judiciary, looking at what the obstacles to cooperation are, and finding a mechanism for that. The two MOUs that have been drafted since the Goldman Act are the MOU involving Saudi Arabia and the MOU with respect to Taiwan. Both are incredibly general. They do not actually provide a protocol for what should happen next with respect to developing an alternate mechanism to be able to work these cases. I believe that one of the difficulties is that there is not a use by the Department of State of technical expertise in order to look at, speaking with attorneys in the United States and attorneys in the subject countries, to try to draft a path toward how the needle can be moved, how we can begin to open a dialogue, how we can develop, in some cases, for example, some remedy. The United Arab Emirates is on the list of countries that are non-compliant. There are legal protocols that can be used in the United Arab Emirates that if we have a conversation and talk about using them, it may not be applicable to every case, it may not provide a blanket remedy, but it's a way that we can begin to use their legal structure to be able to work the problem. Because otherwise, as I've said before in my testimony before this commission, it means that every parent has to become a diplomat. These are systemic problems. They're not individual problems to a case. The cases have enough individual problems. These parents aren't looking for the work that an individual legal advocate would do. They're looking for a path. Show me the path. I'll do the work. With regard to the reporting itself and the issues of areas of deep concern, although Central and South America does not completely populate the countries which are non-compliant, even those countries that are deemed to be compliant, there are significant problems with regard to the use of public prosecutors and their lack of advocacy on behalf of American parents. That issue has to be looked at systemically. What are the obstacles to return? Where are parents being prevented from having their cases advanced properly because the public prosecutor is not acting on their case or purposefully delay? We have that significantly in Ecuador. We have that a number of places in which that device is used to prevent parents from using the treaty. Finally, I've made some recommendations, but one of the other recommendations that, again, to me is very much like a Groundhog Day is the Prevent Departure program. First of all, I will say that I've had the opportunity to use that program. I've been able to see our Homeland Security, this is Article 3 of the Act, our Homeland Security actively get involved and prevent an abduction. They're very adept at what they do. The problem is that right now, parents are not aware that this is something that can be easily done. There's not a form of order that attorneys and judges can immediately access, and they should be able to. And there isn't a clear path and description for how a request to have border control is actually transmitted and adopted by Homeland. I sat in a briefing, a DOD briefing, in which this program was discussed. I asked the attorney for the Department of State to indicate what was the process for identifying that the child had been put on the list, and communicating that information back to the judge who issued it, so that, for example, the access could be unsupervised, or so that we could the child's circumstance normalized. The first answer was, that's classified. And I said, well, wait a minute. I said, I'm not asking you how the child, physically or technologically, how the child's name is placed on the list. I'm asking you, what process do you have to communicate back to the judge who signed the order that the child's on the list? And the answer was that there was no mechanism to do that. That is something that's deeply important, so that a judge can say, for example, fine, now I understand that I can permit shared access. Now that I understand that I can permit that there be unsupervised access. There has to be a mechanism for a streamlined and effective way of getting this done. The bottom line is that, in my view, this act does not need additional tools. It needs to actually see the importance and the coordination of these issues with the entire work of the Department of State. I would propose that I still believe that there needs to be an ambassador-level slot, an ambassador at large on this issue, so that there can be coordination and communication, particularly on the request for the imposition of diplomatic sanctions. Although they've never testified to it, I have to believe that part of the problem with regard to the use of the diplomatic remedies is that even if a country is identified as non-compliant, and even if the Office of Children's Issues were to make a recommendation, they're starting from the bottom. They now have to run the gauntlet of the remainder of the departments of the United States Department of State. Whereas if there were an ambassador-level position, negotiations of MOUs, communication of diplomatic remedies, the other things that are very important to have the efficacy of this act take place would be elevated in a way that I don't believe that it is now. The fact of the matter is that a tremendous amount of good has been done. With respect to this commission, I would recommend that there be continuing conversations and hearings with regard to 3 issues. One is, there has not been a hearing with regard to domestic violence issues and its relationship with the removal and retention of children. The fact of the matter is, it's a reality. And this act and the reporting function may provide ways of, again, preventing the pretextual use, as well as making sure that where there are systemic problems with respect to protection from domestic violence, they can be identified. With respect to the relationship of child trafficking and kidnapping of a child to use as a commodity, that is a different type of child abduction and is something that needs to be addressed in light of the TVPA. I would indicate that using the private remedies for victims under the TVPA has become astronomically difficult. It is almost impossible to weave your way through the number of statutory elements in order to define how a victim, and in this case a victim and a parent of a victim, can be provided remedies from trafficking. And finally, the human rights report that's issued by the Department of State should be linked to the abduction report. Where the United States Department of State has identified systemic issues, lack of access to justice, lack of ability to have treaty compliance on a human rights basis, there should be an automatic link back. Those 2 things should be read together. Again, it's been my privilege to provide my written remarks and to have an opportunity to, as a practitioner in this area, to share my observations and those of my colleagues. I look forward to any questions you may have, not only with respect to today's hearing, but at any point in the future in assisting the Commission with regard to its work.
Ms. Abbey, thank you very much for your testimony. Before going to Mr. Morehouse, we have been joined by James McGovern, our co-chair of the Lantos Commission, so yield such time as he may consume.
Thank you. Thank you. I want to thank Co-Chair Smith for convening today's hearing on the problem of international parental child abduction. And I join him in welcoming our witnesses, 2 of whom have directly suffered the consequences of such abductions. And let me just say that I very much regret that you've had to go through such an experience. And I also want to thank Ms. Happy for her testimony and for her recommendations. I think they're all good recommendations that we should follow up on. And I want to apologize for coming in late and being in and out here. This is the crazy week here in Congress, and we're trying to make sure we don't default on our financial obligations. So Rules Committee is meeting, and so I will be listening and two hearings at once, trying to keep the government running and so on. But let me just say this: International Parental Child Abduction, or IPCA as it's known for short, refers to the wrongful removal of a child from their country of habitual residence or the wrongful detention of a child outside that country. It is a violation both of the rights of a child outside the, I'm sorry, is a violation of both the rights of the left behind parent and the rights of the child, including the right not to be separated from their parents against their will. This is a problem that members of Congress have been concerned about for decades. And let me say to my co-chair, Mr. Smith, no one, and I mean no one, in the United States Congress, House or Senate, has been a bigger advocate of doing something about this issue than him. And I want to applaud him. To the extent that we've done anything good and positive, it's as a result of his urging and his steadfast advocacy. Since 1980, Congress has been enacting laws meant to prevent and sanction this practice, and laws have also been passed at the state level. The U.S. became a state party to the Hague Convention on International Child Abduction in 1988. The Commission has held the first ever congressional hearing on international child abduction in December of 2009. The Goldman Act passed in 2014 and named for a family that suffered child abduction, gave the State Department stronger diplomatic tools to seek the return of children removed illegally from the United States. These efforts over time have yielded some results. The number of children reported abducted from the United States has declined consistently over time, and thousands of children have been returned. And I applaud the work that the State Department does on these cases and believe that they're on the right track. But there are still hundreds of children and hundreds of parents who are caught in a morass of competing judicial systems, mixed in with differences in cultural and social expectations, nationalistic attitudes, and gender stereotypes. Fighting for the return of a child is a costly and emotionally draining process that can take years. Meanwhile, children grow up without access to one of their parents. Even one of these cases is one too many. So I look forward to hearing the views of the witnesses. Again, Ms. Happy, thank you for your testimony, to find out what more we can do here as a government, as a Congress, to help resolve these cases. Figuring out what more to do begins with knowing what is already working, so we can build on that. I would also like to know what more can be done to prevent international child abduction in the first place. Here, I want to acknowledge the role that abuse or violence in the home can play in a caretaker's decision to flee with a child. To the extent that domestic violence has evolved, it seems clear that prevention efforts must be linked with ending domestic violence. I'm also interested in whether regional human rights systems might offer additional legal channels for some left-behind parents. The Hague Convention lacks a supranational enforcement mechanism, but for states that are consistently out of compliance with their Hague obligations, several of which are in the Americas, perhaps there's an opportunity for some creative litigation via the International American Human Rights System. A first step could be a regional thematic hearing before the Inter-American Human Rights Commission. So again, I want to thank you all for being here. This is an important topic. And again, let me sing the praises of Co-Chair Smith for all that he has done on this. He's a leader on this, and we've been following his example. And again, thank you for letting me come in. I'll be in and out, but let me yield back to Mr. Smith.
Thank you very much. I say that the co-chair, Jim McGovern, we do work as a team, and I think that's important on so many human rights issues, including international parental child abduction. So thank you. And I did advise everyone here that you were literally on the floor with the rule, which we just voted on. So I thank you for coming back, and I know you have another hearing that you're a part of as well, so, or even chairing with the Rules Committee. So thank you again for joining us, Jim, and thank you for your kind words. And you were at the 2009 hearing, and so was Patricia Appy, and me, and David Goldman. So I'd like to now yield to Mr. Morehouse for his comments.
Thank you, Co-Chairman Smith, Co-Chairman McGovern, and the Commission for inviting me here today to share my expertise and personal experience with the ongoing human rights crisis and crime of international parental child abduction. Bring Abducted Children Home is a nonprofit organization dedicated to the immediate return of internationally abducted children being wrongfully detained in Japan, and strives to end Japan's human rights violations of denying children unfettered access to both parents. We collaborate with an international alliance of partners working to end child abduction to and within Japan. We're also founding partners in the Coalition to End International Parental Child Abduction, uniting organizations to work passionately to end international parental kidnapping of children through advocacy and public policy reform. Japan is internationally known as a black hole for child abduction. According to U.S. government figures, there have been more than 475 U.S. children kidnapped to Japan since 1994. The government of Japan supports international parental child abduction and the violation of our human rights while persistently failing to aid in the reunification and return of our victimized children. For 7 years, the Goldman Act has not been used to its potential by the State Department. It's overdue for an overhaul to obligate state to be true to its intent to return our kidnapped children. Co-Chairman Smith, in your opening remarks of the April 6, 2017 House hearing titled "Enforcement is Not Optional, the Goldman Act to Return Abducted American Children," you said, "We need to apply the Goldman Act sanctions to Japan. Yes, they're a friend and an ally, all the more reason. Friends don't let friends commit human rights abuses." Today, in Japan, Fumio Kishida was elected LDP president and will become the next prime minister of Japan. In your opening remarks of the April 11, 2018 hearing, No Abducted Child Left Behind, an update on the Goldman Act, you highlighted that on February 14, 2017, a month into the new Trump administration's tenure, Japanese Minister of Foreign Affairs, Kishida, noted in the Diet discussion on abduction that, and I quote him, "Until now, there is not a single example in which the U.S. applied the Goldman Act sanctions toward a foreign country." He went on to note that, according to the United States, Japan is not included in the category of non-compliant countries. In other words, no fear, hasn't been used, will not be used, and Japan is off the list. We're now in the third administration since the Goldman Act was signed into law. The State Department and the administrations they've served have demonstrated that they are quite comfortable letting Japan and other countries keep our kidnapped children. They may occasionally express sympathy for it, but they don't commit to the action that is needed. They plod along without oversight or consequences. In a July 16, 2015 hearing in Congress, Special Advisor for Children's Issues, Ambassador Susan Jacobs, testified that the top 3 worst offending countries are Brazil, India, and Japan. She furthered that we get cooperation from some of these countries, but we don't get the returns. On May 25th, 2018, my colleague and I met with Japanese embassy officials to try and better understand if there was a genuine path for Japan to reunite parents with their kidnapped children. The head of Chancery, Mr. Takuya Sasayama, was shockingly candid when he said to us, "Your access depends on the mother and the child's wishes." State Department officials met with the Japanese Central Authority again in November 2018 to raise cases for the umpteenth time of American children kidnapped to Japan and the lack of progress and failures in enforcement of judicial rulings. And there were 3 important points in it. Japan acknowledged that, 1, enforcing an order depends on the voluntary cooperation of the kidnapping parent. And 2, if this parent refuses, there are no repercussions for ignoring an application for access, return, or a court order. And 3, the kidnapping parents know this. Japan admits the problem, deflects its responsibility, and blames it on the kidnapper. As we muster the strength to beg for scraps of assistance from the U.S. government, parents are frequently ignored or told, "You're on your own. Please consider filing another legal motion in a foreign country that won't be enforced, and kindly go away." It is a constant marginalization and re-traumatization of the victimized community. The pain and isolation is so great that tragically some do not survive. In my case, I was granted sole custody of my son, Mochi Atomu Imoto Morehouse, in the state of Washington in May 2007. All Japanese consulates and their embassy in the U.S. was notified twice in writing of my sole custody and the court orders barring her, from my ex-wife, from holding or obtaining a passport for our son or leaving the state. When the Seattle Consulate of Japan denied her passport request in April of 2010, she simply went to the Japanese consulate in Portland, 2.5 hours away, which issued one in violation of the Ministry of Foreign Affairs passport issuance policy. I've won 2 lengthy legal cases in Japan where the courts ruled the U.S. custody order has legal effect, and then they refused to provide any reunification. The last time I saw my child, the last time I heard his voice, was on Father's Day, 2010, when I dropped him off to visit his mother. Under Article 21, under the provision for access under the Hague Abduction Convention in Japan, it's been useless because it's unenforceable, and it relies on the kidnapping parents to voluntarily comply. In 2014, back home assisted parents by securing pro bono counsel, which resulted in more than 30 applications for access to be submitted on the day the convention went into effect. In 2017, we checked with these parents again for progress. 3 parents reported receiving 1 Skype session, and 1 received 3 sessions before the kidnapping parent cut them off. None of these parents received the true unrestricted access to their kidnapped children that the convention mandates. In my case, the kidnapping parent weaponized my application against Mochi and me and filed a separate motion that lasted 2 more years in court in Japan. After it concluded, she refused to respond to requests for access mediation, which was passed back and forth between our central authority and theirs. I was later encouraged to file another motion in Japan, but filing a motion for access in Japan was not a practical option, since compliance with an order for access would have been at the discretion of the kidnapper, and she has no incentive or obligation to obey it. My son demonstrated the violation of his human rights when he told his attorney in the autumn of 2016, "I sometimes dream of my father at night." And then tears rolled down his face, helpless, because no one protects his human right to reunite with me and come home. He holds his pain, his trauma alone. His abductor, with the assistance of the Japanese government, silence him. While silencing kidnapped children to and within Japan and providing direct and indirect support for kidnapping parents, the Japanese government continues to enlist the U.S. to help it resolve the 1977 to 1983 kidnappings of 17 Japanese citizens to North Korea. I feel for those parents. I understand their pain. It's our pain. We should help. It's the right thing to do. Former Prime Minister Abe publicly used President Obama and President Trump for help. Both presidents, while in office, met with Japanese families and made public statements of support. Outgoing Prime Minister Suga continued this, again with President Trump and toward President Biden. On July 20th, 2021, the Office of the Spokesman issued a readout of the meeting between the Japanese Vice Foreign Minister and U.S. Deputy Secretary of State. Spokesperson Ned Pearson wrote, Deputy Secretary Sherman reiterated U.S. commitment to the immediate resolution of the abduction issue. So I immediately emailed the Deputy Secretary and her Chief of Staff to clarify if the support was for the more than 475 U.S. children kidnapped to Japan since 1994, or Japan's desire for assistance with the abduction victims to North Korea. I received no response. Are the human rights of kidnapped American children and their traumatized parents of interest to those that are at the steering wheel for U.S. policy? In Japan, the leading candidates for LDP party president this month voiced intention to continue to engage on the North Korean abduction issue, as they should. But this means that Japan will continue to enlist President Biden privately and publicly through the press to continue to meet with Japanese families and lend U.S. backing when the winner, Mr. Kishida, becomes Prime Minister. In my 11 years of advocacy work, I've been to the White House more than once about focusing policy on international parental child abduction to a policy of reunite and return children. Next time I'm there, a true sign of support will be for President Biden to meet and stand for public photos with the press for the more than 475 American children kidnapped to Japan. 2 years ago, the law firm Zimmer & Fennell filed a complaint against Japan with the United Nations Human Rights Council, accusing it of conducting a pattern of serious violations on the rights of the child. On May 15th, 2018, as Japan was about to be cited for international parental child abduction by the United States, they held a public seminar at the House of Culture in Japan in Paris, co-organized by the Ministry of Foreign Affairs of Japan and the Japan Bar Association. In an audio recording from inside this event, we hear participants being educated about the Hague Convention on the civil aspects of international parental child abduction. They're also taught how to prevent having their children returned to France should they take them without consent to live in Japan. More simply put, the organizers taught them how to kidnap and get away with it. This act of complicity was first exposed and published by Back Home on November 8th, 2018. More recently, this past month, the Sydney Morning Herald reported it was one of 18 organized by the Japanese government around the world. The Japanese government is a shameless co-conspirator. Last year, the European Union passed a resolution on Japan, and in its press release, they stated, ministers in the European Parliament are concerned over the high number of parental child abduction cases due to the reluctance of Japanese authorities to comply with international law. There's also reluctance by the State Department to uphold the intent of the Goldman Act. So let's get it fixed. For 7 years, the State Department has refused to use the tools provided by Congress beyond demarches. Their annual action report on international child abduction is littered with these letters. It's not going to improve without legislative measures. This has been explored in multiple hearings in the House and the Senate. It's essential to create an escalation of tools that requires that they are issued from the Secretary directly, or at least the ambassadors in our embassies. There needs to be weight behind the message and the messenger. There must be a shift from the policy of resolving cases to a commitment to reunite and return our kidnapped loved ones. When countries transition from non-Hague to Hague signatory countries, as was the case with Japan in 2014, and more than a dozen other countries since, all pre-convention cases were reclassified as access cases in the Secretary of State's annual report on international parental-child abduction. Hundreds of kidnapped children were erased when evaluating Japan for noncompliance. If our children were counted as intended by Congress, Japan would be cited every year. Do not let them continue to invalidate our children. Let's fix the law. There should be a full accounting for how many children have been kidnapped to each country and how many returned to the United States. The reporting requirements in the Goldman Act will benefit from a redefining to include historical data for kidnappings and returns for the previous 10 years for each country so that trends are transparent. When state closes a case without the child being returned and decides it's resolved, there should be clear data for the category that they've selected included in the annual report. Was it a judicial or administrative ruling that caused it to be closed? Did the parent withdraw the request for return? Was it a voluntary agreement? Did the parent or child unfortunately pass away? Were they unable to locate the parent for more than a year? Or did the kidnapping victim turn 16 and age out? We need to see why cases are closed. The State Department's focus on the term open cases opaquely implies progress. Figures provided to the Senate Judiciary Committee in 2018 and a report I saw last summer from state shows that most children never make it home. Concealing information leaves the full story shrouded in mystery from the American people and Congress. It fails thousands and thousands of parents and our 25,000 to 30,000 children that have been kidnapped from the United States since 1994 when the Office of Children's Issues was formed to work on this issue. Let's fix the law. We need consistent and meaningful response from state and a whole of government commitment to maximize action to reunite and return our children. Start with our ally and friend, Japan. We've all tried talking with them about this ongoing human rights abuse of our children and the children within Japan that are victims of parental-child abduction for more than a decade. It's time for punitive action from Congress, so Japan hears and understands that the United States demands our kidnapped children are reunited and returned. Thank you.
Thank you so very, very much for that very powerful testimony. And I would now like to call on Dr. Hunter.
Thank you. Thank you, Co-Chairman Smith, Co-Chairman McGovern, for this opportunity to offer testimony before the Tom Lantos Human Rights Commission hearing on the rights of the parents and children, how to better implement the Goldman Act on child abduction. I'm Dr. Noelle Hunter. I'm president and co-founder of a voluntary nonprofit, I Stand Parent Network. We empower parents to return their children from international parental-child abduction, and we advocate for policy reform to end this painful crime against children and families. I Stand works in close cooperation with the Coalition to End International Parental-Child Abduction to seek transparent, forceful government engagement to prevent and end international child abductions. I'm also the mother of a formerly abducted child. In 2014, my daughter came home to me after a nearly 3-year abduction to Mali, West Africa. My daughter is home today. She's in Washington today with other IPCA survivors because I love her and I fought for her, and because every public agency and actor with the authority and capacity and capabilities to intervene on her behalf were fully engaged in the mission for Muna, my daughter's name. I'm also a political scientist and a lecturer at the University of Alabama in Huntsville. And it is from that perspective that I would like to first pose some questions to the U.S. Department of State, though they are not present. If representatives from that department were here, I would ask, do the rights of American children end when they are stolen from our contiguous borders? But they are not present for me to ask this. I would ask this because of the extreme response variation among our embassies abroad as parents seek the support of our government to work cooperatively and assertively with foreign nations to end their captivity. If the Bureau of Consular Affairs had sent a representative to this meeting, I would ask why the rights of American children and parents are continually subordinate to geopolitical priorities at best or intentionally subverted by discretionary decision makers here and at U.S. Post Abroad at worst. But they are not present to respond. If the State Department were here, those very same officials who insist year over year that American children are a top priority would perhaps give account for why children like Brian Sung languish in South Korea, despite his father's 3 Hague orders and a return order in his favor. Who was it at the State Department that called his case a, quote, failure of enforcement? Let him come and testify. I'd ask why Secretary Blinken is not leading on this truly low-hanging fruit. And I'd question the extent to which he has been made aware of this long-standing policy problem at all. As a lecturer in international relations, I would ask the State Department why they seem enchanted with démarches, the tiny stick which would they gently assail nations with diplomatic wrist slaps for patterns of noncompliance in returning America's stolen children, when the Goldman Act is replete with escalating, weighty enforcement tools. But they are not here for me to inquire. I'd ask about the fate of American children who are trapped in nations in which there are no Hague partnerships, no bilateral agreements. Indeed, my daughter was in one of those nations, and yet she received the full weight of her government behind me, actualizing her rights as an American citizen. In the end, we were escorted out of the country, out of Mali, by United States Marines and by the U.S. ambassador to Mali herself. Why did we get such treatment, such validation of our rights, and other parents do not? I cannot ask this question, Mr. Co-Chairman, because they are not present. I am here in Washington with a delegation of college students who I'm privileged to teach in a special topics course on international parental child abduction. Mr. Co-Chairman, would you believe that in the first 3 weeks of class, having no prior knowledge of this issue, they raised the very same questions that we as a coalition, as parents, have been asking for over a decade, and questions that Congress has asked and received pat answers to. Answers that are but variations on the theme of soft diplomacy and the advancement of the Hague Convention as the right remedy. If the State Department were here, I would ask them a simple question. How do they know that soft diplomacy and the Hague Convention are the best tools to resolve abductions when they haven't tried any of the others? I would ask why countries such as Brazil, India, and Costa Rica continue to benefit from government largesse in the form of international aid, despite absolutely abysmal records of noncompliance in returning American children. To the point of Costa Rica, I would ask why sweet Camille continues to be endangered by her abductor, who is empowered by that nation to perpetuate her abuse and abduction, while her father, John Stefanik, continues to receive favorable court orders and decisions in favor of Camille's return. The sad, self-evident answers to these questions prompt one more. Co-Chairman Smith, Co-Chairman McGovern, does the State Department's absence at this hearing signal to this commission, to the American people, and to this particular constituency that it does not view international parental child abduction as a human rights issue, as a children's issue? I think the answer is also self-evident. We know, as my colleague testified, that the State Department does prioritize some human rights and take strong positions against human rights abuses in other nations. Its annual human rights reports demonstrate our nation's keen interest in highlighting internationally recognized individual, civil, political, and workers' rights as set forth in the Universal Declaration of Human Rights and other international agreements. That's a direct quote from their website. Yet, international parental-child abduction does not fall neatly into any of the specified policy areas asserted or articulated in the Bureau of Democracy, Human Rights, and Labor's website. So perhaps the State Department has an out of sorts. And we know from experience, unfortunate experience, that it will gladly take an out when it can concerning America's stolen children. Those outs usually sound something like every case is different, or that the United States government can't force a sovereign nation to act on this issue. Not true, not true. We do it all the time. Coercive diplomacy is alive and well at the State Department. Consider my daughter's case, in which the very hint of economic or diplomatic consequences was enough for Molly to send her home. Co-Chairman Smith, Co-Chairman McGovern, I'm saddened to say that I knew that they would not come. I knew that when this hearing was announced that decisions and non-decisions would proliferate from the policy and political desk and flow down to the Office of Children's Issues. I knew that there would suddenly be other priorities which would keep the right officials from coming here to give account for the under-implementation of the Goldman Act. I take no joy in this foreknowledge. Rather, my heart hurts for Jeffrey, for all of the other parents and families who perceive this absence as a signal of non-commitment with which we've become quite familiar. Their absence speaks volumes and belies the popular refrain that the return of American children is a top priority for the State Department. I've always been taught that people show up for priorities. And so the question before us now, before this distinguished commission, is in the absence of State Department consistency, transparency, and true commitment to all of America's internationally abducted children, how shall Congress require better implementation of the Goldman Act as a means to protect the rights of children and families? We must answer for the State Department because they are not present. I recommend respectfully that Congress diversify your sources of information on IPCA in order to better understand the complex intersections of international relations, human rights, children's rights, and public policy. More and more diverse research is needed to address this policy problem and to root out policy failures that permit years and decades to lapse for parents like my colleague and Vikram Jagtani and others. I am joined today by 13 students from the University of Alabama in Huntsville, where I'm honored to be on faculty and teach this special topics course on international parental-child abduction. Again, in the first 3 weeks of class, these bright students raised questions that we have been asking for almost a decade. They quickly surmised that Congress is constrained from acting more vigorously upon this issue because it receives most of the information from the very department and agencies tasked with implementation. Aside from an occasional report from the Congressional Research Service, Congress really doesn't know the extent to which international parental-child abduction is a wholesale policy problem, not just a constituent issue. My students and I discovered that apart from these reports, the only information is coming from a source that has a vested interest in promulgating narratives that support its inadequate policy response. I recommend that the Commission author a study on the current state of research on IPCA. You will also quickly find that the most off-cited research is 10 to 20 years old. The world has changed considerably over time and even in the past 2 years. How do we know, again, that these tactics employed by the State Department have kept apace with the changing norms and practices and ways to ameliorate this issue? We do not. And we need the information from another source. We need to triangulate information, good information, and not subjectively submitted and, in some cases, whitewashed information. The pandemic has put us in uncharted waters, and parents are left to tread these seas of ambiguity with typically little guidance and less help from the very federal agencies that are tasked with helping us bring our children home. We need new data, new research, and new paradigms from which to approach and act upon this problem. Finally, I recommend that the Commission consider the ways in which this issue is managed at our U.S. posts around the world. I can say from experience in my case and as an advocate that there is extreme variation in the ways in which abduction cases are handled at posts abroad. You've heard about my exemplary experience on the ground in Mali and coming home. But what about the New York father in Kenya who couldn't get a basic courtesy response from the U.S. Embassy in Kenya for almost 2 weeks? Meanwhile, his son was continued to be endangered in that country. What about the veritable cadre of parents of children abducted to India, as was mentioned earlier, who can't get more than courtesy responses from our government and outright disdain and hostility from India? This is one area in which standardization can empower parents and also lead to protection and articulation of children's rights to be with their families and not to be separated from their children, in accordance with the Convention on the Rights of the Child. It is my understanding that each embassy should have a strategic plan and a designated officer to work with these parents on these cases. Is this happening? I respectfully ask the Commission to find out, to request these strategic plans be submitted as part of a fact-finding initiative. I wish I were optimistic that these plans and these designated officers and this approach are in place or at every post. Perhaps the State Department is present, consistently present overseas for America's stolen children, even if they are not present here today. I somehow doubt it. Thank you, sir.
Thank you very much, Dr. Hunter. Again, totally comprehensive. The fact that there were individual people within the State Department, Foreign Service officers and an ambassador who were very keen on helping you help make a difference. And we do find that that is the case in some places. I remember even with David Goldman, the policy side people were obtuse, they would smile, shake your hand, and do nothing. But the welfare whereabouts that was being undertaken by the consular people, I mean, they were as empathetic as you could be, and never the two should meet in some of these cases. That's so unfortunate. So thank you for those recommendations. You know, we're hoping, and if they're not, we'll send them a copy, that personnel over at the U.S. Department of State are watching this to hear you. I mean, this three unbelievably powerful witnesses who speak truth to power. Congress should be listening, but the implementers of the Goldman Act, which is the State Department, and the Biden administration need to be listening as well. And I'm hoping, and I will do my part, we will do our part as a team. You heard Jim McGovern, he is totally on board as well. Use this hearing again as a pivot. I mean, everybody has been so preoccupied with COVID-19 that a lot of enforcement of human rights norms and laws have lagged. And so I do have a few specific questions I'd like to ask. And we will again ask until State comes here and answers the questions that you've posed and questions that I and other members of the Commission, the Lantos Commission, would like to ask as well. And we are looking at some additional legislation. The Ambassador at Large, I think Patricia Appy, is a tremendous idea. I offered an amendment, it took years to get passed, for an ambassador at large for combating anti-Semitism. I wrote our law on human trafficking, and it took the second time around to get an ambassador at large there. That does bring a gravitas to that position. He or she are then in a better position to not just speak to other countries, but to have power within the Department of State and access to the President's ear on these vital issues. So we're going to pursue that as well. So thank you again. You are a font of best practices. You all are. So thank you. You know, in your testimony, Ms. Appy, you made a you talked about the report seems to be growing less specific, difficult for judges, lawyers, and parents to navigate, misleading in their conclusions, and burdened by ubiquitous boilerplate language that render the content unhelpful. I would point out that when it comes to recommendations, the Trafficking Victims Protection Act, which does a country-by-country narrative, and I wrote the law that created this, so I watch it very carefully. I read the entire book every year when it comes out. It has recommendations to that country that are very specific on how they can improve and combat the heinous crime of sex and labor trafficking. Go through every country. There it is. If you could speak to that, because you really pointed out something, the boilerplate language, it says the department will insert country. There's always this language that says insert country, which you're talking about, they put in the country, but it's the same thing. And if I'm that country reading this, I'm saying, that lack of specificity certainly shows that less of a prioritization and a concern. And I think that's what we're all concerned about here, that there's been a deprioritization Remember the first two reports, how bad they were, how inaccurate they were? We had the hearings, and maybe that's why they don't want to come back, because, we have to hold to account the executive branch. It's one of the three main jobs of Congress: write law, constituent casework, and oversight. And oversight certainly needs to be done here. So if you could speak to that, if you would, and also, and the others, if you'd like to speak to it as well. You also talked about the, you had a number of great recommendations. The idea that not to be focusing on aspirational goals, but to really be very, it's in your recommendations part, measures require the department to accurately portray the current status or compliance or cooperation, not aspirational goals. If you could speak to that as well and elaborate, and others might want to speak to it as well. And then the whole idea of all dated MOUs need to be reevaluated and revised. And the MOU with China, where is it? I mean, I traveled over with the Eliases years ago. I mean, this is years ago. Met with lots of top people within the Japanese government, our own embassy, a number of internationals from other embassies who came together, and it was a very good meeting because they have abducted children from their countries as well. And I said, the MOU is the key, especially, Captain Toland, who is here, who has painstakingly worked to get his daughter back. I'll never forget. Here's a man in the military who is in Yokohama and gets bad advice from the JAG, and he ends up in a very, very bad situation vis-a-vis his own daughter, and has, with great love and devotion, like you, Jeffrey, just has never stopped pursuing this, and you do it so civilly. I'm amazed, that you really are amazing. And the Japanese government should take note of that. And again, I hope the Biden administration takes note, and I'm glad you re-quoted it, Jeffrey, and that is when Fumio Kishida, I should say, said, until now, there's not a single example of which the United States applied these sanctions, Goldman Act sanctions, toward foreign countries. If you don't use the sanctions embedded in the law, it leads to almost precisely the opposite. They think we're bluffing, and we're not bluffing. Congress certainly isn't bluffing, and my hope and prayer and appeal to the administration is don't bluff, use it. If our civil rights didn't have a sanctions aspect to them, a consequence, Title VII, all the other important civil rights laws of the United States of America, there would have been lack or non-compliance throughout all of these decades. You got to have an enforcement regime that is real and predictable, and Japan certainly needs it now, and other countries too. But if you could start speaking to some of those questions.
With respect to the content of the report and this watering down of information, I mean, when we had the testimony originally that preceded the finalization of the form of legislation, the TIP report, which has only continued to become more and more specific, was the gold standard, was the example that was used in the reference that was used. And part of the reason for that, just in the same way that the TIP report is utilized in the application of domestic criminal law and international criminal law, this report in 16 states of the United States, applying the Uniform Act with respect to the prevention of child abduction, this is required to be referred to by a judge. So in my written remarks, I quoted, there are only 3 lines. It's not as if it's that you have a significant number of options. They're either saying the department will continue intense engagement with fill in the blank to address areas of concern, or they're saying the department will engage with insert country regarding potential partnership, or they're saying that for countries that are non-signatories, the department will continue to engage, fill in the blank, to accede to the Hague Convention, period. Now, if that were accompanied in the 90-day action report with specificity, I might say it's merely a tab that you're being sought to. But as Mr. Morehouse shared with us, the action report is a correspondence list. It includes a reference of meetings that have been held, but it does not indicate, there is not a single action report that references a recommendation for a diplomatic sanction. There is nowhere in any of the information that's provided where there has been a request or any type of information that references steps to take the analysis of recalcitrance beyond the Office of Children's Issues and the Bureau of Consular Affairs. That's significantly concerning because it's antithetical to what this particular reporting structure was designed. It was always designed to provide the general information, to identify the obstacles to recovery, and then to provide for accountability of the Department of State within 90 days to develop a strategy with respect to each country and identify what specific actions were being taken, particularly focused on the non-conforming. So from the standpoint of the issues that, and the reporting requirement, the report now does very little to identify not only why, what the noncompliance is, but more importantly, what the obstacles are. I didn't include, because I've testified 3 prior times about the independent circumstances of Japan, but in the articulate testimony that we have heard, looking at the use and misuse of the accounting portions of the Goldman Act could find no better example. When we see, and I did take the opportunity in my report to quote from the 2000 report that was issued by the Department of State with respect to child abduction, well before we had the Goldman Act. And I quoted the whole response with respect to the concept of a resolved case and the issues with respect to a resolved case. I believe that the reporting functions have been diluted so significantly so that they can be manipulated diplomatically within the context of other issues that have been raised. And as Dr. Hunter has indicated, that has been enhanced by maintaining all of the reporting function in an isolated and non-integrative path without reference to the human rights reports, without reference to an accountability directly to the higher decision makers at the Department of State. I would also indicate that the issue of training and direct accountability of the individuals within each embassy is an incredibly important part of this issue. I have had, contrary to the example, I have had members of our embassy say that it is not their job to be involved with respect to assisting in efforts that I have done, footnote, to use the legal process within an individual country, and I'm asking for simple consular services to support those efforts, whether it's having someone present in a courtroom so that it's obvious that the United States is concerned about steps being taken, particularly in countries in which, an example would be Pakistan, where the beginning efforts of the application of the treaty are so important. I have to concur that one of the machinations that have been used within this reporting function and continue to be diluted is the excising of historic information and the purposeful lack of carryover with regard to the relationship between ongoing cases and resolved cases. And I did go through those definitional issues. Finally, I'm completely baffled as to the lack of willingness to utilize an MOU structure. This commission should know that throughout the world, there are serious questions being raised regarding the Hague Abduction Convention at this point in time. It's beyond the scope of today, but some of the countries that you would identify as the most cooperative in terms of their central authorities are seeing judicial developments. My report references some deep concerns with respect to Israel, a country I work in collaboratively and regularly. Those issues are not issues with respect to systemic central authority problems, but they're issues with regard to judicial performance and enforcement. And the fact is that nothing about those issues appears in the report. In places like the state in which I practice, we have a significant population of individuals who travel regularly and whose families live regularly back and forth. There are other countries where not knowing this creates significant risks with regard to future abduction issues. The fact of the matter is, with respect to recovery of children, the issues are broken. With regard to prevention, we're at a place that if this report continues to be diluted and continues to reflect nothing other than boilerplate language, we're going to start to have an uptick once again in our prevention numbers. And judges are going to look at it for what it is, and that is something that's unuseful to them and bears no relationship to the risk factor analysis that they have to engage in order to apply preventative measures.
Like to address any of that? Because, Jeffrey, you did speak in your testimony at great length about, reuniting as opposed to closing cases, and what a crock that turns out to be.
Yeah,
You
absolutely.
close it for all these reasons, it looks good on paper. Wow, we're making progress, and we're not.
And as you may recall, when the Goldman Act was working its way through Congress, back when they were showing up for hearings, when they were invited, they suddenly pivoted to talking about open cases. And I remember your staff, and we all looked at each other confused, because prior to that, they were reporting at the hearings how many children had been kidnapped. And I think that was a very intentional move on their part to continue to marginalize parents and families and marginalize this issue so that it wasn't a priority in the State Department to reunite and return. With respect to the accounting, and thank you for mentioning it in your response, Ms. Zappi, I'm very, very deeply concerned about our families and friends with kidnapped children to India. When India in the future, eventually, when it happens, when they accede to the convention, and we don't know when that will be, but it's a similar path Japan went down, without fixes to the Goldman Act, the State Department will continue this pattern, and all of those children will be wiped clean. India will be effectively rewarded for signing on to the convention. So one of the things we did back in 2018, after a series of discussions with the State Department on why are you removing these pre-convention cases? And I know your office took that up with them many, many times. And as I recall, staff at the time said, we're not getting a clear answer. And so I kept going at them and finally was engaging back and forth in letters with legal staff in consular affairs and got them to identify their reasoning for removing cases. And I'll be happy to share that with the commission and your staff. But their argument was it was a procedural, it was an order in which the law that was written allowed them or required them to not include pre-convention cases. So it may be a simple fix, but I would also in lay terms say these are the dirty tricks that we suffer through when we're trying to bring our children back to the United States because of other policy objectives. As Dr. Hunter mentioned, there are geopolitical concerns. And to that end, with regard to getting help from embassy officials, I remember on one of my trips to Japan in 2017, in fact, you helped and you had written a letter to Ambassador Hagerty, who's now Senator Hagerty of Tennessee. Hopefully he gets back involved in this issue now that he's in the Senate. We'll be reaching out to his office. I hope yours will as well. The person I met with, I think it was the chief of American Citizen Services, I spoke to him very frankly and I said, my concern is that the kidnapping of American children is being conflated with other concerns and objectives of the United States. And he looked at me as a seasoned diplomat and he said, I can't imagine that. Absolutely it is. If it weren't, we'd be much further along. My good friend and co-founder of our organization, Paul Toland, who's sitting back here with me, he would have been reunited with his daughter years ago. I would have been reunited with my son years ago based on legal standing alone. Michael Elias's children would be reunited, and scores of others. So we need these kinds of changes, I think, in the Goldman Act, because clearly after 7 years, the State Department is not going to move beyond the litters of letters that are démarches. And as the incoming Prime Minister of Japan noted a couple of years ago, we don't follow through. So it's time to see some change so they understand the U.S. government is committed to the reunification and return of our kidnapped children from Japan and other countries.
Yes, Dr. Honor.
Thank you. I wanted to add another anecdotal experience and then repeat part of a conversation that I had with State Department officials. So to this point about extreme variation in how these issues are handled at our U.S. embassies abroad, my organization was very pleased and honored to help return a young lady who had been abducted to Egypt when she was very young. And back in January, I traveled to Egypt, and beyond getting a passport from the embassy there was no help for us. Even what's more, not only was there no help in getting this young lady out of the country from her government, but in the end, we had to rely on an expat from Canada who lived in Egypt, who knew how the system worked, and was able to circumvent the idea or the suggestion the State Department sent us to this child welfare agency, who absolutely insisted that this child must get her father's permission. The very father that abducted her and made it nearly impossible for her to communicate with her family. Our embassy sent us to this social service agency, and it was only working with this expat who knew the system that we were able to get around that and get her, what she needed to be able to exit Egypt. The embassy would not even escort her through the airport. An ambassador put me on the plane and kissed me on the cheeks, and my daughter on the cheeks, and they wouldn't even escort this child traveling alone through the airport. We had to pay $100 to an escort agency. That's extreme variation, and it's unnecessary. And I agree with my colleagues in that unless the State Department is forced to acknowledge the way in which it handles this issue and the inadequacy, that we'll continue to see these cases, and it's very unfortunate and unnecessary. Thank you.
Let me ask you if, are there countries that exhibit a pattern of noncompliance that should be on the list that are not? And I would just preface that with, again, having written the Trafficking Victims Protection Act law of 2000, a few years back, there were Reuters, 3 reporters from Reuters did an investigative report that found that, contrary to what the TIP office, Trafficking Persons Office, wanted, more than a dozen countries were artificially given a better grade, and therefore they weren't sanctionable, in order to advance some other issue. For example, one of the countries that helped us with, helped the United States with the Iran nuclear deal, Oman, artificially got a passing grade. Malaysia got a passing grade because certain people within the administration, and this is the Obama administration, wanted them to be part of the TPP, which was a trade deal. Cuba was artificially elevated as well because we wanted a rapprochement with Havana. Therefore, don't be hitting them on this issue. So it was like this currency that was able to, and that's on human trafficking, and concurrent and equally important on child abduction, parental child abduction. My feeling, and just so you know, I held 2 hearings on it, and one of the hearings was next time get it right when you do your report, because you got it wrong. And I asked Secretary of State John Kerry, right there where you sit, Patricia Abbey, when he testified as Secretary of State, who made that decision? He said, the buck stops with me. He did. I said, you can't play games with the report. You can't give an artificially passing grade somehow they're doing better than they are, because you absolutely demoralize the left behind parents in this case and the children, in that case, victims of trafficking. So I just raise it, if any of you could speak to whether or not you think there are other countries that ought to be on that list, I would appreciate that.
As was mentioned by Dr. Hunter, one of the
Yes.
problems we have is that the folks keeping the numbers are how, unless like myself, you actually practice in this area and have experience, you would not have access, as a matter of law, to the information. In fact, members of Congress aren't notified unless permission is given by the parent, and the State Department doesn't spend a lot of time counseling that there are advantages to having your member of Congress notified.
And as you know, we put that into the Goldman Act.
Exactly. But for example, and when counsel, one of my colleagues in preparing my remarks indicated that the difficulty in, even if their client indicates that there's permission to talk to the lawyer, the difficulty in having the Department of State respond and speak candidly about the issues, and they're not going to talk about any other aspect of what's going on in the country. So everything happens in sort of a cone of silence. And other than the conversations that occur in this kind of a forum, there really isn't any way to completely evaluate. You have to start looking at the case law, which is why I've suggested that their responsibility to identify the obstacles to recovery in a country across the board is an important piece to be able to actually see if there are trends with respect to these issues. I would note that the Central and South American countries, in addition to the ones that are listed as non-compliant, continue to be a tremendous difficulty. And while I acknowledge the recommendation of Co-Chairman McGovern and the suggestion of making an application to the Inter-American Court of Human Rights, one of the things to understand is no individual parent would have standing. So the problem will be that the Department of State would have to engage the representation with respect to the United States of America, arguing that a country is not treaty compliant and is acting to deprive human rights in the context of parental abduction. Well, what are the chances of that when they won't take the internal diplomatic mechanisms available to them? And why would you delay the application of those remedies by suing before the Inter-American Court? I respect, of course, the suggestion, but practically speaking, we're caught in a bad loop. I think Mr. Morehouse's suggestion and continued attention with regard to those countries that become Hague signatories, leaving those numbers of children whose abductions occurred beforehand, that's not the part that worries me the most. The part that worries me the most is Japan is demonstrating for the rest of the world how to avoid any of these, any of the actual purposes of the Abduction Convention. And by doing so, without any censure from the United States, it signals that it doesn't matter if you sign off on this, because there's really no teeth in it. This is a unique piece of a unique law. It has a unique impact on domestic law in the United States, while at the same time having an incredible impact around the world. This is an important report, not just for us, because no other country engages in an objective review of the actual status, and most certainly the Hague Conference does not. If we continue to dilute this process and to relegate this as not only a diplomatic priority, but not an actual priority, if you will, then we will be essentially identifying that this isn't any more important than the most perfunctory administrative processes that Consular Affairs does. It's just one of those things, and if it works, great, and if it doesn't, no big deal. That's not what this is. The fact is that most Americans don't really understand foreign policy unless it shows up in their living room. And the fact of the matter is that this is one of the few places that American citizens can understand the impact of foreign policy upon their lives and the lives of their friends and the lives of their countrymen. But we're not getting it right. We're not actually, and by the way, this has been across the board. There has not been, just so we're clear, the current administration, the prior administration, there is the real problem here is the idea that defending the United States of America is different than defending Americans for the Department of State. That somehow the interests are inherently different. And the Goldman Act is written to identify what the responsibilities of the Department of State is to not only Americans, but to the world as it relates to this human rights violation. The answer that the Department of State will not have a public discussion with respect to that is very concerning. While I appreciate that they may be willing to have private briefings on the point, it can't be enough, because the fact of the matter is no one serving in a private briefing is going to have enough information to come back and say, well, wait a minute, that's not the way it's actually being applied. And so, again, we're in a loop where we don't have any information available. As I suggested, having practitioners involved, having parents whose lives have been subjected to this is very important for accountability purposes, and having a strategic plan for how this is going to be made better.
Mr. Co-Chairman, I just wanted to thank you for this opportunity. I apologize, I am going to need to step away here in just a few moments. All of these parents who have come to Washington, D.C. will be gathering in front of the U.S. Capitol, in front of the Capitol Reflecting Pool, to honor their internationally abducted children, to call upon members of Congress to act both from a constituent perspective and a policy perspective, to hold our State Department, our Justice Department, our Department of Homeland Security, and nations accountable for better performance and returns on this issue. I'm pleased to say that we have seen much better prevention mechanisms put into place, and that's great, and that's a direct credit to you and to Ms. Appy and to all of those who contributed to the Goldman Act. But in the same fashion that they're not here today, the State Department is not here to give account, this is not something that our parent community is going to forget. It's not a threat. It is just an indication, as we're about to gather, that it's time for us to continue to escalate. That means more pressure on members of Congress, to put more pressure on the State Department. And so on their behalf, and many of them would have liked to have been here today, but of course these COVID restrictions that you acknowledge prevented them from doing so. But I carry, most of them have probably been tuning into this, and so I will carry what has been suggested here, the recommendations, and importantly, your longstanding commitment to this issue to them as we gather to honor America's stolen children. Thank you.
Thank you very much, Dr. Hunter. And you're right about, we do have to triple our efforts. I mean, the State Department should be here. They should be doing more. You have provided tremendous recommendations and guidance. You know, it's like so much more needs to be done, period. And again, as we've said over and over again, there are so many tools embedded in the Goldman Act, including sanctions. Use them, and they'll be shocked and positively shocked at the results that will be gleaned from that. So I thank you for, of course, I know you have to go. Thank you. Jeffrey.
Yes, thank you, Mr. Co-Chairman. To address your question, are there countries that are being left off the report? We kind of don't really know, because they are the controllers of the information to engineer the result that they may want. We can speculate. I would argue certainly Japan would be consistently on there. There are probably many others. But without having all of the information on the cases and why they have resolved them, are there an overwhelming number of cases that have been resolved because they haven't been in communication with the parent for more than a year? I'd be interested to know, because that would raise the question of, like, how hard have they tried? I certainly know many parents on the Japan front that don't know who their country officer is, because state's approach is reactive rather than proactive to let them know that you've changed country officers. And I believe I'm on my 12th now in 11 years, so there's no consistency there either. I think there's also opportunity to look at, if there's understanding of why cases are resolved. Were they resolved for a judicial ruling or administrative authority ruling in that country? I think that would be very illustrative of what is occurring in that country. Do we need to examine that further? Should there be criticism of what's happening, those unfair rulings? James Cook's case, who has testified here before, after one of the last hearings, they overruled it in the Supreme Court, found some obtuse excuse, and his children were never returned. Also understanding that baseline of how many children have been kidnapped to a particular country and returned, I think, is informative, because it takes it away from looking at the open case data, which they love to promote, without giving us a whole pie picture. I think all of those things combined will help give Congress, the American people, attorneys practicing in the field trying to explain to a judge, I would think, no, Your Honor, it's very clear. It's not safe to let that child go to Bangladesh, and here's why. Here are the numbers. Children go and they don't come back. It doesn't matter what state is saying about open cases. So I think numbers and data and transparency are essential, that will then inform and clarify what countries actually should be on, and then improve, hopefully, the tools in the sanctions. Make them perhaps obligated. You get one démarche.
Yeah.
You try it one time. Now, if you see them sequentially, which one could argue possibly they are, possibly they aren't, but you move right on to the next one. If they haven't improved, you move on. And have it delivered by the Secretary of State, or at least the ambassador in that country, or as Ms. Appy suggested, which I think is a wonderful idea too, an ambassador at large that is in the policy section or directly in the Secretary of State's office at the Power Center and not down below in consular affairs and children's issues, a part of government that actually is empowered to fight for the reunification return of our children. That would be helpful too.
I do want to thank you both. Oh, Ms. Abbey?
The other issue I would indicate is that we have bases, we have armed forces bases around the world, and the lack of attention to the specific problems and obstacles to recovery in those countries have an incredibly deleterious effect. The training of our judge advocates, they have a lot on their plates, and we try to supplement it as much as we can. But the fact is that if there is not a commitment to identifying these obstacles and being legitimate in their numbers, then judge advocates who have even less access to information because of the breadth of the work that they do, and will be looking at a report like this and making recommendations to a service member to make decisions, and then finding that they have absolutely no recourse. So I would just say that this, there are a number of aspects. We don't have an updated report on the joint working group that is supposed to include our service members in DOD. I'm usually pretty keyed into those meetings and what the developments are, and all through COVID, when we were having tremendous issues, when there were do not move orders for the military, I don't understand that there was a single meeting that was conducted. So again, it's beyond the, I say it's beyond the scope, but it's really not. We really need to have a review with the Department of State, going line by line through the Goldman Act and addressing the issues and hearing their responses, and then talking so that they take ownership and accountability before we start spending our time on legislative, and I support legislation, but not so that it can be misused by policymakers to say, well, when you get done with that, we'll look at it again. I'm just concerned that some of what we need to do happen within the scope of the law we have, and accountability happen now.
No, I appreciate that. And we will continue inviting the Department of State to come and testify, and I do believe that persistence will pay off. They will be here at some point in the near future. and we'll ask them a number of questions. And I'll meet privately anytime, anywhere as well, but not in lieu of. There needs to be transparency. We also, I think, need to be pushing very hard. You know, the parents, left behind parents, before the Japanese government ratified The Hague. When I traveled over there, when I went to the Japanese embassy, they all would talk in glowing terms, especially the Department of State, about how we just want them to sign The Hague. And every time I'd say, but what about pre-Hague cases? How could you, you know, without an MOU, without a real means of effectuating their return, this ratification of The Hague will not just be a bad day, it'll be a catastrophically bad day for them. And we're not even seeing much progress with Hague either in Japan. I'm sure you can attest to that, and maybe you would want to. But it was like this false sense, and that ate up several years of talking points from people from the Department of State when they sat right where you sat with regards to Japan. And you know, it's like, you don't get it. What if that was your child, like it is your children, two of you sitting right here, who you can't even get to see, but you know, it's just too much. I mean, there was Captain Tolan, part of the defense of Japan against all aggressors, working, you know, in our armed services, and they do this to him. I find that, and will always find that, to be absolutely appalling, that that's how they mistreated our military personnel in Japan and Okinawa and elsewhere. So I just, you know, we will continue working as hard as we possibly can, but I think we have to recommit as never before, because I think there is backpedaling going on. And again, as you said, Mr. Morehouse, there must be a shift in the policy of resolving cases. In your testimony, you said this, to a commitment to reunite and return our kidnapped loved ones. And if you want to make any final comment, either of you, or we will just end the hearing then. Thank you. We finish on your words then, Mr. Morehouse. The hearing is adjourned, and thank you.